Welcome back to the Sutliff and Stout Legal Podcast. I'm Abby, and today I'm here with Hank Stout from Sutliff and Stout. Good to have you back, Hank. Thanks for being here today.
Glad to be here, Abby.
Today, we are talking about what happens after a car accident in Houston. We are going to cover everything from what to do at the scene to how Texas's fault-based insurance system works, the filing deadlines, dealing with insurance companies, and actually need a lawyer. If you have been in a crash in Harris County or anywhere in Texas, this episode is for you. So most people panic after a crash and have no idea what to do first. What should someone in Houston do right after a car accident to protect themselves and their claim?
So the first thing somebody should do is make sure that everybody is safe and the occupants are safe. Depending on where the crash occurs, you may or may not want to get out of your vehicle. If you're on the freeway, I suggest not getting out of your vehicle until emergency people arrive. Unless your car is drivable, and then under Texas law, you should try to move it to the side. If you can get out and take photographs safely, then I suggest doing that. Also, gathering up information about who is there, why they're there, what they saw. Pictures are great. Anybody who has dash cam video would also be helpful. Pictures of the surrounding area, meaning are there gas stations or other businesses that might have surveillance that captured what occurred. That way you can actually have video evidence of what actually happened so that stories don't change down the road when the at-fault driver tries to say that he or she is not at fault.
And most people don't realize there's a separate state reporting requirement beyond the police report. Are you legally required to report every car accident in Texas, and what are the actual rules?
You don't have to file a report with the police about a collision. I mean, it's helpful to. I mean, we always suggest that you do, because if you don't and it's not documented, then the insurance company has a he said versus she said. And so it's just your word against the other person's. Whereas a police report kind of gives a definitive document that says, this is the problem, this is what happened, and here are the people involved.
A lot of people walk away feeling fine and skip the doctor entirely after an accident. So where should someone in Houston go for medical care after a crash, even if they feel fine?
So that actually happens quite a bit. The adrenaline associated with the car accident, you feel like you're a little shooken up, but you don't really hurt. And then several hours later or a day later, you wake up the next day and your neck hurts, your back hurts. You have a tingling sensation down into your legs or your arms. Those are not normal feelings, and you should definitely go get checked out. We suggest that folks go to urgent care if possible, or if their injuries are really bad or their symptoms are really bad, they should go to the ER. There's a difference, right? I mean, emergency rooms cost a little bit more than urgent cares. And so, we suggest people go to urgent care to kind of figure out what's wrong and then have a doctor assess, do they need to see a specialist for their back or neck or whatever part of their body may be hurting.
All right. So thank you for those answers. We have covered what to do at the scene in Houston. You can call 911, document everything, get medical care, even if you feel fine, and file the forms needed. Now let's get into how Texas's insurance system actually works. So most people don't know how fault actually works in Texas. How does Texas's fault-based insurance system work when it comes to car accident claims?
Sure. So an insurance company has some obligations, right? They have an obligation to investigate and then make a determination as to whether they believe they are at fault or their insured's at fault or not. And then they have an obligation to pay what is fair value. Now, there's a lot of wiggle room with all of that because Texas is a proportionate fault state, meaning that a jury is asked to weigh how much one person versus the other is at fault for a collision. And so oftentimes insurance companies also say, well, we're only accepting 60% of responsibility, or we're only accepting 55% of responsibility as just a way to reduce the amount that they have to pay out on a claim. Just like they'll say, well, we'll pay what we think are reasonable bills, but we don't think the ER bill that you got from the hospital is reasonable, so we won't pay that, right? And so oftentimes as a lawyer, that's a lot of the arguments that I'm dealing with, or the arguments of the insurance company trying to find ways to reduce their overall exposure in a case.
And kind of going off that, drivers sometimes don't realize how low the minimum coverage actually is. What are Texas's minimum auto insurance requirements, and why do they matter if you are the one filing the claim?
Sure. So just because you're involved in an and you have damages doesn't necessarily mean that the person who hit you has the ability to pay your damages. We see it all the time where someone in wrongful death cases or horrific injury cases where the at-fault person doesn't have enough insurance coverage. The minimum in the state of Texas is $30,000 per person, $60,000 per accident. What that means is that on a per accident basis, let's say if there's 3 people in the car, the most the insurance company will ever have to pay out is $60,000. Whereas if there's just one person in the car, because it's a per person limit, the most that they'll ever have to pay out is $30,000. And so those are the minimum at fault insurance coverages. There are other types of coverages that are required to be on your policy unless you specifically waive those coverages, but those are different and those are for the policy holder or the occupants of the vehicle, like underinsured motorist coverage or personal injury protection coverage. So those are additional coverages that the state says you have to include, but they can be specifically waived if you sign a particular document.
That's a great answer. Super informative. And this is one of those rules that can completely change the outcome of a claim. How does Texas's modified comparative negligence rule affect a car accident claim in Houston?
Sure. So different states have different rules when it comes to comparative fault. Texas is a modified proportionate responsibility, meaning that if you're at fault greater than 51%, then you do not recover anything. Whereas if you're only 49% responsible, then you can recover the 51% of damages that you aren't responsible. Some states are what are called no fault, meaning you can't have contribute to the collision at all. Other states are what are called pure comparative fault. Texas, though, is a modified, and it's the 51% bar. And so what we're looking at there is, were your actions part of the cause of the collision? And if so, did they contribute greater than 51%? If not, you can recover. If they were greater than 51%, then you won't be able to recover.
And so let's say someone has been in an accident, they have documented everything, they have been to the doctor. Now what? How do you actually file an insurance claim step by step in Texas, and who should you contact first?
So the first step of opening a claim is to contact the at-fault insurance company. When doing so, you're going to be asked a whole host of questions. You'll be asked for the police report, and then eventually you'll get assigned a claim number and a claims adjuster. You need to keep that claim number and the information for the claims adjuster because that's the person who you'll be dealing with as it relates to the collision. Oftentimes, a claims adjuster will ask a person to give a recorded statement. We do not suggest that you do that. They would not allow you to take a recorded statement of their insured, and so it doesn't necessarily benefit you to do that. And then you tell the adjuster that you'll send them records. When you send the records, you need to make sure to include the claim number so that they can file them properly, so that you can keep them informed as to the extent of your injuries. And then eventually, if you're handling the claim yourself, you'll have to talk to the adjuster about your damages and what you think the case is worth.
Yeah, most people assume that the adjuster is on their side, but what should a Houston car accident victim expect when the adjuster calls, and what should they not do?
Sure. So adjusters are people like you and me, but they have a job to do. And their job is to try to pay as little on a claim as possible so that they can save their company as much money as possible. And so you're going to hear a whole host of arguments of why they can't pay certain amounts. They'll often come to you and say, oh, well, we'll give you $2,500 now if you just sign this release. If you do that and you have extensive damages, well, you've just capped your ability. You will get no more than the $2,500. Sometimes they'll say, oh, well, we'll give you $2,500 and we'll pay your reasonable medical bills. Well, the devil's in the details, right? The question about what is reasonable, because the bill you get, let's say from Memorial Hermann, might be for $60,000. Well, the insurance company's not going to give you $60,000 for that Memorial Hermann medical bill. They're going to say, well, that the reasonable value of those services was $5,000. And so we're only going to give you $5,000, right? And so you have to be very careful. The insurance adjuster knows what all of these things mean. They know what meanings they're attaching to it, and you typically won't. And so you want to make sure that you are careful about how you proceed so you don't get taken advantage of.
Yeah, we are flying through these questions. You've got great answers. Do you have any specific examples or case examples about Texas's fault system, comparative negligence, 51% bar, or adjusters and insurance companies?
A great example is that oftentimes speed will be an issue in a case. And so my client was driving down the road and he was traveling 10 miles or 15 miles an hour over the speed limit. But then somebody pulls out in front of him, fails to yield the right of way, and then there's a collision, right? And so oftentimes the defense will argue, well, because you were speeding, you too are at fault for this collision, even though my client or my insured ran the stop sign, it's still also your fault. And so we deal with that on a daily basis. The reality is that at the end of the day, a jury gets to decide what they think is fair. And if they think that your speed contributed to the collision, then they can attribute some fault to you. But typically in situations like that, it won't be much, 10, 15% fault, maybe, because most people have gone 10 miles an hour over the speed limit or 15 miles an hour over the speed limit. And they understand that people have an obligation to stop at a stop sign, and you can reasonably anticipate that people will stop at a stop sign. So, but that doesn't prevent the insurance companies from making those arguments. And they're not making the arguments because they truly believe it. They're making the arguments because they know that it's going to save them some money.
All right, thank you for that example. We have covered Texas's fault system, 30, 60, 25 minimums, comparative negligence with the 51% bar, and how to handle the insurance company. Now let's talk about the legal deadlines and court process specific to Houston and Harris County. This is one of those deadlines that can end your case permanently. How long does someone in Houston actually have to file a car accident claim under Texas law?
Sure. So typically when you talk about deadlines in a normal personal injury case, you're talking about a statute of limitations. And the statute of limitations in the state of Texas is 2 years from the date of the incident. What that means is that you have 2 years from the date of the collision to file a lawsuit. If you do not file a lawsuit, then the other side can have your case dismissed for failure to bring it in a timely manner. Meaning you can still file the lawsuit 3 years after the collision, but the other side has what's called an affirmative defense that they can then show that your case was filed after the statute of limitations and therefore it's time barred. And so that is the key thing is the 2 years from the date of the incident. But I highly recommend to anybody who's been involved in a collision that if you have substantial injuries, that you hire a lawyer and that you proceed quickly with the initiation of litigation, because setting aside the statute of limitations, it takes 3 to 4 years to get to trial in Harris County. And so the sooner you file your lawsuit and put yourself in line, the sooner you'll actually get a trial date. And that's the thing that's going to be the most important to you or to a person who's significantly injured is that trial date, because that allows the jury to determine what your case is worth.
Is that the same for personal injury, property damage, wrongful death, those statute of limitations?
General negligence, any kind of general negligence claims are 2 years in the state of Texas. There are, some intentional torts that are 1 year, but just general negligence, car accident, wrongful death, it's all 2 years. I mean, sometimes your statute of limitations will get told if, let's say, like I represent a lot of families whose families or loved one was killed in an accident. If there's minor children, then the statute of limitations is told for a period of time until after they reach the age of 18. And then they have a certain amount of time to then go file a claim. But again, that's not to the benefit of the child to wait. It's better to go ahead and proceed. There are other unique circumstances where a statute of limitations can get told due to incapacity, meaning you didn't have capacity or mental capacity to file a claim, and therefore the statute of limitations would toll in those circumstances, but those are very rare. And I mean, I've had to deal with those before, but generally it's 2 years. And so that's what you should kind of focus on.
Yeah, you're jumping right into the next question too. There are exceptions to that 2 year standard. One of them catches a lot of people off guard. So are there situations in Texas where filing deadlines get extended or shortened? So you mentioned minors. Is there anything else?
Sure. So the statute of limitations applies to adults, right, who have capacity. And that's in the general negligence case, it's 2 years. The legislature has changed some of the statute of limitations for, let's say, like sexual assault claims. They've extended it, especially for minors, because you have a delayed outcry. Sometimes there's something known as the discovery rule. So like if something happened to you and you didn't know that it was there, then the courts won't necessarily impose a 2 year statute of limitations because it's so much time from the time that you knew or should have known that the problem existed. And then sometimes if you're suing a governmental entity, then your statute of limitations doesn't get shortened, but then you also have to give what's called notice. And if you fail to give notice in a timely manner, then your claim can be barred as well.
And beyond the basics, there's a lot of evidence that can tip the scale. What most for a car accident claim in Houston?
Well, obviously, dash cam is probably the best piece of evidence that you can get because it shows people definitively what happened. And then you're not really arguing over who did what, you actually see what happened. But sometimes cases aren't about liability, right? A lot of cases where it's clear the other side's at fault. I was just involved in one where an 18-wheeler pulled into an oncoming lane of traffic and unfortunately killed a woman. And in that case, the fight wasn't about, who was at fault. The fight was about, well, what is the value, right? And so that's, what are the best pieces of evidence there? And that all just depends. I mean, it's medical records, it's testimony from loved ones describing the relationship that she had with her family. It's wage records. Those are the types of things that help a person and a lawyer develop a damage model so that a jury can understand, the impact that a particular collision has had on a family's life.
Yeah, people will assume it's just the car repairs and the medical bills, but what can someone recover in a car accident claim in Texas?
So there's two types of general damages or what are called compensatory damages, right? There's two categories of compensatory damages, and that's to compensate the individual who was injured. They're called economic damages and non-economic damages. Those are two broad categories. And so first, let's talk about economic damages. Economic damages are past medical bills, future medical bills, like how much is the treatment a person's going to need as a result of their injuries. That's recoverable under the law. Same thing with like lost wages in the past. I mean, that's recoverable under the law. Also, too, the loss of wage earning capacity, meaning your inability to do a job in the future, you can recover those. That's all economic damages, and you can there's receipts and doctors and experts who will talk about those types of damages and the extent of those damages and the value of those damages so that you can give the jury an idea on those numbers. The second category of damages is called non-economic damages, and that's pain and suffering, mental anguish, disfigurement, the mental injuries, right? Because I think we can all agree that the quality of a person's life has a tremendous deal of value. And so it's the loss of that value that juries are asked to compensate for, the pain and the suffering. How has this affected your activities of daily living? How has this affected your relationship with your wife? How has it affected your relationship with your children? Those are all things that can be compensated depending on the type of injury, and that juries then have to assess. And so those are the general types of damages. And then there's a third type of damage. You have compensatory damages, but you also have what are called exemplary damages or punitive damages. And those are just damages to punish the wrongdoer, meaning they did something that's so bad that the jury should punish them for their behavior. And those are called punitive damages. And those are completely different than what are called compensatory damages.
Okay, sounds great. Houston has some unique factors that don't exist in other cities. What makes Houston car accidents different from other cities, and how do those local factors affect claims?
Sure. As the fourth largest city in the country, we have a very large population of drivers and a very complicated freeway system. And so those factors alone kind of complicate how you have to handle a case, how you deal with the various drivers in the population, and then the injuries associated with those types of claims, especially at high speeds, are much more severe. And so they can make the types of claims that you handle larger and more significant because the injuries are more significant.
We have covered the legal deadlines, the evidence you need, what you can recover, and what makes Houston accidents unique. Now let's talk about finding the right attorney and whether to settle or go to court in Harris County. So a lot of people are not sure if their case is big enough to justify calling a lawyer. When should someone in Houston actually pick up the phone and call a car accident attorney?
That's a great question, Abby. I highly recommend that if you were involved in an accident and you have residual pain that's lasting longer than a day or two, that you should pick up the phone and talk to a lawyer about what your options are. Most lawyers, my firm included, do not charge anything to talk to us. There's a free consultation, and so it doesn't cost you anything to talk to a lawyer. So you might as well get some basic information and some basic facts to kind of help you make a good decision for yourself, because this isn't a circumstance that you'll find yourself in on a daily basis. Okay.
And that was a lot of people hear free consultation, but are not sure what happens after that. How does the fee structure work if someone hires a car accident attorney in Houston?
Sure. As a personal injury plaintiff's attorney, I work on a contingency fee basis, which means that I only recover money or get paid if my clients recover. And so it's kind of a no fee guarantee. If my clients don't recover any money, then they don't owe me any money.
The insurance company makes an offer, and now there is a real decision to make. How does someone decide whether to take the settlement or go to trial in Harris County?
The way I recommend all my clients to make that decision is to look at it the same way that a jury would look at your case. What would a jury likely do in your case? How much would they give you for your lost wages? How much would they give you for your medical damages? How much would they pay you for your pain and suffering? And then you have a comparison point to the offer that you've been given. Do you think the offer is reasonable? Typically, an insurance company is not going to pay you what they think a jury is going to give. They want to give you something less. And that's okay as long as it's within the range of reasonableness, because nobody knows exactly what a jury is going to do. And so that's how you have a kind of a baseline or a point of reference when you're deciding, well, is this a reasonable amount to take? And that's how I encourage my clients to look at it, because that's how the insurance company is looking at it, right? I mean, it's a business for them. And so you need to look at it as a business decision and try to not look at it as a personal decision.
That's great advice. And I'm sure you see people make the same mistake over and over. What are the biggest mistakes you see car accident victims in Houston make that hurt their claim?
The biggest thing is thinking that the insurance company is going to treat you fairly, right? I mean, like they thinking that, oh, well, surely they'll treat me fairly. I mean, that's it, it's nice to think that, but that's not the way it happens, right? I mean, insurance company is all too happy to let your statute of limitations run. They're all too happy to pay you minimum value on your claim. They're all too happy to not pay you at all. And so we have an adversarial process. And so if you're not out there advocating for yourself, then you're not going to get, fair value for your claim. And so that's the biggest mistake that I see people.
And have you ever seen insurance companies monitor everything, like if a client is posting on social media about the accident or anything like that?
Sure. So anything you post on social media can be found. Insurance companies most definitely start looking at your social media pages and to see what you're posting, to see if it's inconsistent or they can claim that it's inconsistent with your injuries. And so you want to be careful about what you post because it can be taken out of context. I do the same when I look at defendants. I look at their Facebook pages. I try to see, what type of person it is and what they've been doing and what they're up to. And so you just want to be, conscientious of that fact and make sure that you're only posting things that you would want others to see. And then obviously insurance companies can hire investigators to conduct surveillance, and there's people sitting outside in cars videotaping you. I mean, there's all kinds of things that they do to try to get, a snapshot of something that shows that you're doing something that supposedly is inconsistent. Typically that's not fair, right? I mean, typically, if you're walking outside of your car, it doesn't mean you're not injured. It just means that you're walking outside of your car. And so, it's not a fair process, and the insurance company is not going to be fair to you. And so understanding that and proceeding accordingly is the best way to go.
And Houston has massive rideshare volume, and commercial trucks are everywhere on the highways. How do rideshare accidents, truck crashes, and commercial traffic change the claim process in Houston?
Sure. So Lyft and Uber have become widespread use. Waymo is coming online and a bunch of other different types of services. And so those services have various drivers, and you have to understand how the insurance works because Uber and Lyft take no responsibility for the ride that you're on. They have insurance that covers those drivers when they are actually in the middle of a trip. But then there's different limits that'll cover you. And so it's a very specific type of situation that you have to look at and kind of understand the insurance. But just because Uber's involved doesn't mean that you can hold Uber at fault. When you start talking about like commercial trucks and things of that nature, that's also very specialized. And so you really have to understand, okay, well, who am I dealing with? Is it actually the truck driver? Is it a broker? Is it a co-motor carrier? I mean, there's a whole slew of different people that can be involved. And so really understanding who you're dealing with and what insurance rates apply and what policies apply, it's very important.
We're coming up on the last couple questions. Do you have any, again, case examples about anything that involved a rideshare or commercial trucks?
So we regularly sue individuals who are driving for Lyft or Uber, and for whether if they're at fault, then they have to be held responsible, and we'll deal with the insurance companies that have for those claims. And then we regularly represent folks who have been injured by 18-wheelers. And so that's one of those things that we kind of specialize in, and we take a great deal of pride in being able to maximize the value of our clients' claims in those situations and finding all of the available insurance. Because in the trucking industry especially, you have drivers who will drive trucks, but then they're hired by all these other third parties. Well, those third parties can also be responsible for that driver under certain circumstances. And so it's kind of one of our specialties is to look at that and kind of figure out exactly who is responsible for this driver in addition to just his own insurance policy.
For someone listening right now who has been in a car accident in Houston, what is the one thing you want them to remember?
The one thing I'd tell people to remember is it doesn't cost you anything to give us a call and let us give you the information that you'll need in order to make a good decision. Don't go into something at a disadvantage. At least have the benefit of information about the process so that you can make good decisions for you and your family.
And if someone wants to talk to you about their car accident claim, what is the best way to reach Sutliff and Stout?
Sure. The best way is through our website, sutliffandstout.com. There's a form there you can fill out, or you can give us a call at 713-987-7111.
And just making sure whoever's listening caught what you said earlier, that first consultation, that is free, right?
Yes, ma'am.
Okay. If you have been in a car accident in Houston and you are not sure what to do next, make that call. You can find Sutliff and Stout at sutliffstout.com or call them directly at 713-987-7111. Thanks for watching, and we will see you on the next episode of the Sutliff and Stout Legal Podcast.